All right. The moment a federal judge stops performing patience is not a moment that announces itself through the ordinary machinery of public attention. It doesn't arrive as a headline with the velocity of breaking news or as the kind of statement that gets read into the record with cameras positioned to capture the gravity of it. It arrives as something quieter and more permanent, a specific recalibration in the institutional posture of someone whose position in the constitutional architecture means that when the recalibration happens, the downstream consequences aren't measured in news cycles. They're measured in the kind of documentation that outlasts every political framing operation ever constructed around it. What happened in the Bondi situation, what the final phase looks like when, the judge presiding over the most consequential intersection of law and executive power in the current political landscape, stops treating me. Space between the operation's preferred narrative and the documented. Record as a gap worth waiting for the operation to close is a thing the Trump team understood before the public version of understanding it had anywhere to land. The signal was in the architecture of what didn't happen, in the specific quality of the silence from people whose professional obligation to this situation made their silence the loudest signal in the room, in the particular register of the statements that did emerge the quality of their aggression, the precision of their deflection, the telling asymmetry between the volume directed at questions that weren't the point and the strategic quiet surrounding the ones that were. When the people who built the defense start managing the space between the defense and the record rather than defending the defense itself, the people watching from the technical remove that institutional standing provides don't need a press release to tell them what that transition means. They have a word for it. The word is terminal. And what terminal means when the people using it are the ones who built the legal architecture the situation is now running out of that, is the distance the coverage of this moment has been circling without crossing since the final phase locked in. Here is what the lock-in actually produced. Here is what the judge's posture means when the posture belongs to someone with a specific authority to translate it into binding institutional fact. And here is why the room where the Trump team is managing the aftermath is not the room the public narrative has located the consequential decisions in. The Bondi situation didn't reach its final phase without a history. Nothing at this level of institutional weight and legal consequence reaches a final phase without the specific accumulation of preceding phases that the final phase is the resolution of. The judge didn't arrive at lock-in from nowhere. The lock-in arrived at the end of a sequence, a documented, institutionally recorded sequence of events, filings, responses, and the formal silences that carry as much evidentiary weight in a federal proceeding as any statement entered into the record with counsel's signature on it. The sequence had geography. It had a direction. And the direction it was moving in the specific trajectory of a situation in which the legal architecture supporting the executive operations theory of the Justice Department's relationship to political control was being tested against the constitutional framework that predates any particular theory of that relationship and will survive every political resolution of every particular situation that tests it was visible to the people whose professional obligation is to track trajectory with the kind of unsentimental technical clarity that stripping away the preferred framing requires. The Trump team built its theory of the second term with the specific lessons of the first term incorporated into its architecture. That is not a small thing. The first term generated a body of documentation, a record of friction, resistance, independent action, and institutional constraint that the operations architects studied with the granular attention that experienced operators bring to the task of understanding exactly where a theory failed and exactly how to rebuild the failure points into something stronger. The Bondi appointment was the embodiment of that rebuilt theory. It was the second term answer to the first term, problem the answer to the documented experience of what happens when the Justice Department retains enough institutional independence to generate records that the political operation hadn't chosen to generate and couldn't retroactively. contain once they existed. The rebuilt theory assumed that the failure points had been identified completely. It assumed that the reconfiguration of the relationship between political, leadership, and the Justice Department's operational autonomy had been designed tightly enough that the categories of friction that generated consequential documentation in the first term would not recur in. The second, in the specific form that makes documentation consequential, that makes it the kind of record that courts read and oversight, mechanisms engage with and congressional actors with independent procedural standing use to make decisions about mechanism deployment that aren't inside. The operation's strategic control. What the judges lock in documented what the final phase is the institutional expression of is the specific category of failure that rebuilt theories encounter when the rebuilding was accomplished from a map that didn't include the terrain the rebuilt theory was going to have to traverse. Not because the architects weren't skilled, because the terrain generated by the second term situation was terrain the first term failure map couldn't fully anticipate. Because the legal and constitutional framework doesn't reconfigure the way a personnel decision reconfigures. Because the mechanisms that operate according to their own institutional logic, that engage according to their own reading of the documented record, and produce findings according to their own procedural rules, were doing exactly what they were built to do, in ways that the operations theory of second-term institutional management had priced in theoretically, but was now encountering practically with a compression and a completeness that the theory hadn't fully calibrated for. Start with the posture. Because the posture is where the weight is visible before the weight becomes the story. Federal judges at this level of constitutional consequence don't shift posture casually. The institutional architecture of a federal court is built around the deliberate maintenance of a specific kind of patience, a formal, documented, procedurally structured willingness to allow the executive branch the space to make its arguments, enter its filings, advance its theories of executive authority, and receive the kind of engagement from the court that the adversarial system is designed to produce. That patience isn't unlimited. It isn't designed to be unlimited. It is designed to be extensive enough that when it ends, when the specific threshold of documented inadequacy in the executive position triggers the shift in judicial posture that the Trump team is now navigating the ending carries the evidentiary and institutional weight of everything the patience contained before it expired. The lock-in happened because the filing record reached the threshold. Because the sequence of executive positions, formal responses, and the particular quality of what was offered in the proceedings as the legal and factual basis for the executive branch's theory of its own, authority over the Justice Department's operational decision-making, generated a cumulative document that the judge's independent reading of the constitutional framework couldn't reconcile with the theory the executive position was advancing. Not as a policy disagreement, not as a judicial preference for a different constitutional arrangement, as a documented, formally recorded finding that the legal architecture the operation had, built its second-term theory on, was insufficient, was inadequate to the task it was being asked to perform in precisely the ways that the first term's most consequential legal exposures had pointed toward before. The rebuilding was supposed to have closed those gaps. The Trump team was stunned in the specific technical sense that the word applies to sophisticated operators, not unprepared in the layperson sense. Not surprised in the way people outside the architecture of these situations are surprised when complicated things they weren't tracking resolve suddenly and visibly. Stunned in the operational sense. In the sense that the assessment of where the proceedings were, of what the judge's posture was tracking toward, and on what timeline, of how much runway the operations management architecture had before the lock-in, became the formal institutional reality. It became that assessment was wrong in ways that matter. in ways that the shockwave of the final phase made visible with a speed and a completeness that the operation's response in the hours that followed carried as its most readable signal. Because the response signature of an operation that was genuinely ready for the lock-in looks different from what the world witnessed. It carries a different quality of aggression. It has a different relationship to the questions it deflects, a more selective, more precisely calibrated deflection that demonstrates the operation's control of the distinction between what can be argued and what cannot, rather than the kind of broad, high-volume redirection that is what professional management looks like when the gap between the preferred narrative and the documented record is wider than the management architecture was dimensioned to span. The emotional weight of the final phase isn't located where the coverage has been placing it. It isn't located in the personnel drama in the will she stay or go framing that cable news has constructed around the Bondi situation. Because the personnel frame is the frame that generates the kind of continuous attention that the coverage format rewards. The personnel situation is real. The internal conversations about it are real. The political calculations being made at the highest levels of the operation about the relationship between the documented legal exposure and the operational utility of the appointment going forward are real and consequential. But they are not where the weight is. The weight is in what the lock-in means for the operation's theory of itself for the second-term architecture that the Bondi appointment was the load-bearing element of. The weight is in the specific, documented, institutionally recorded demonstration that the theory as constructed was insufficient to its task in ways the operation can no longer manage narratively, because the insufficiency is now part of a court record that belongs to the court, not to the operation. The weight is in what that insufficiency means for every downstream position the operation was planning to occupy for every subsequent situation in which the theory of the Justice Department's relationship to executive political control was going to be deployed as the operational assumption enabling the operation's broader program. That downstream landscape has changed. It has changed in the specific, permanent geological way that the legal earthquake metaphor was reaching for, not the metaphor of a crisis that a political operation weathers and moves past, but the metaphor of a fundamental shift in the landscape that everything happening after the shift happens inside of. The ground that the operation was planning to build its next phase on is not the ground that exists now. The record, the lock in produced place documentation in institutional structures with their own reading practices, their own procedural authorities, their own independent standing to act on what they have read, and those structures are not inside the operation's informational control in the way that the audiences who receive managed framing are inside it. For people whose relationship to this specific situation is technical and institutional, and whose reading of it comes from direct experience with the architecture that produced it. A former federal official with deep structural knowledge of the executive branch's relationship to judicial oversight, speaking with a specificity that comes from having operated at the intersection of political necessity and legal constraint. The thing that's most significant about the judge's lock-in isn't the immediate legal consequence. It's the signal it sends to every other institutional actor whose decision-making about this operation is being calibrated against the emerging record. When a federal judge at this level reaches the posture the Bondi proceedings produced, the actors watching that posture shift the oversight mechanisms. The congressional actors with independent procedural standing. The institutional players in adjacent processes, whose assessment of the operation's legal and political position shapes their own strategic calculations, receive information that recalibrates everything they were doing before the shift. The lock-in doesn't just determine the outcome of this proceeding. It shapes the terrain of the next one, and the one after that, in ways that the operation's forward planning is now having to account for in real time. A constitutional scholar with specific expertise in executive branch accountability and the limits of political control over independent institutional mechanisms. What I keep returning to when I try to understand the Trump team's reaction to the final phase is the specific quality of the miscalibration it revealed. Not the miscalibration itself. Sophisticated operations miscalibrate. That's what happens when you're operating in environments this legally and politically complex, where the information available for building your model is always incomplete, and the mechanisms you're navigating have their own logic that your model can approximate, but never fully capture. What's significant is what the miscalibration was about. It was about the threshold, about how close the operation was to the limit of what the court's institutional patience would sustain before the patience resolved into the kind of formal finding that produces the documentation the operation had built its entire second-term theory around preventing. Getting that threshold wrong, in the direction the operation got it wrong, in a proceeding with these specific legal and political stakes, that is a calibration failure whose consequences don't stay in this proceeding. A senior political analyst with 2 decades of experience watching high-stakes executive branch situations from the technical remove that institutional access provides. The Trump team's visible response to the lock-in has been professional. Let me be precise about that. It has been the response of people who know how to perform competence and control in situations where the underlying situation is demanding qualities that competence and control cannot fully supply. The message management is sophisticated. The surrogate deployment is disciplined. The strategic use of loudness about peripheral questions and precision silence about central ones is the work of people who have done this before and know exactly what it's designed to accomplish. What it cannot accomplish with the specific category of situation the final phase created resists, no matter how sophisticated the management is, the reduction of the distance between the documented record and the preferred narrative. That distance exists in a register that management doesn't reach. And the people doing the managing know it. A former institutional actor with direct operational knowledge of the legal landscape the situation is navigating. Speaking with the condition that contextualizing details be omitted. The final phase is called the final phase not because it ends the situation, but because it ends the period in which the situation's resolution could still be shaped primarily by the operation's own strategic choices, rather than by the institutional processes the situation has now fully activated. After a judge locks in at this level, the timeline is the court's timeline. The procedural sequence is the court's sequence. The documentation being generated is documentation the court is generating according to its own reading of the record, its own application of the constitutional framework, its own institutional standards for what the relationship between executive authority and independent judicial oversight requires. The operation can participate in that process. It cannot direct it. And the difference between participating in a process and directing it is the difference between the situation the operation built its theory for and the situation the final phase has placed it in. Here is precisely where the situation stands, as the operational consequences of the lock-in are still reverberating through the institutional landscape that the final phase reshaped. The Trump team's forward options are not what they were before the judge's posture shift completed itself into the documented record that the final phase produced. This is the operative fact, not the question of what happens to the Bondi appointment, not the question of what the relationship between the political operation and the Justice Department looks like in the next phase of the calendar. Those questions are real. The answers to them are being constructed in rooms that don't generate press releases. But they are secondary questions. They are the questions the operation is asking about how to navigate the terrain the final phase created, not questions about the terrain itself. The terrain is the operative fact. The documentation is the operative fact. The permanent institutional record that the lock-in produced, and that no political resolution of the personnel situation that generated it reaches or reduces or retroactively contains, That is the ground everything happening after the final phase happens on. Watch the silence now. Watch where it spreads from and what it envelops. Watch the voices that were loudest in the period before the lock-in, and note which of those voices have recalibrated their volume in the aftermath, and which have maintained their frequency at levels that are themselves a form of documentation that signal. To the institutional actors reading the record for the patterns that individual episodes contribute to, the specific operational calculation that loudness at a moment requiring quiet represents. The operation is communicating in those signals, not to the general audience that the management is directed toward. To the institutional actors whose reading of the signal is the reading that shapes forward consequences. Because the judge reading the next filing from the executive branch is reading it in the context of the final phase. The oversight mechanism processing the next request related to the Justice Department's operational decision-making is processing it in the context of the documented pattern the final phase extended. The congressional actor making the decision about whether to deploy the procedural mechanisms available to them in the current political landscape is making that decision in the context of what the lock-in added to the accumulating record of the operations relationship with the constitutional constraints on executive authority. These actors are not reading the operation's preferred framing. They are reading the record. And the record after the final phase reads differently than it did before, carries more institutional weight, points more consistently in a single direction, supplies more clearly the pattern that sustained engagement with independent oversight mechanisms requires to justify its own continuation. The operation understands this. Whatever the public framing suggests about confidence and control, and the operational normality of a situation that its own internal assessment is measuring in vocabulary that has nothing to do with normal, the people making decisions in the quiet rooms understand the record they are now operating inside of. They understand the judge's lock-in not as the dramatic event that the public coverage is treating it as, not as the moment of revelation in a story whose climax is the revelation, but as the formal completion of a process that was already generating its consequences before the lock-in made them publicly visible. The revelation to the people operating with technical clarity about the situation was earlier, was in the quality of the proceedings before the posture shift was complete, was in the filing record before the lock-in was the institutional expression of what the filing record had been building toward. They were not surprised. They were not ready. Those are different things. And the distance between them is where the Trump team is operating right now in the operational space, between having understood intellectually what the final phase was going to produce and being positioned institutionally to manage the environment that the production of it has created. Between preparation that was technical and sophisticated and grounded in the specific lessons of the first term and readiness that would have required the terrain to be what the theory predicted rather than what the lock-in documented it to actually be. The defense was built for a different landscape. The defense was built with care, with experience, with the specific architectural intelligence of people who understood exactly where the first term theory had failed and how to build the second term theory to address those failures. That work is real. That sophistication is real. The limitation it encountered is the limitation every defense encounters when the situation it was built to defend against turns out to be adjacent to, but not identical to, the situation that materializes when the failure map was as complete as it could have been given me. Available information and the available information turned out not to have included the specific terrain feature that the final phase traversed. The record is permanent. That is the sentence that sits at the center of this situation and that the coverage of the lock-in has been describing the perimeter of without reaching the middle. The judge's findings. The documented insufficiency of the executive branch's legal theory as applied to the specific constitutional questions the Bondi proceedings raised. The formal, institutionally generated record of what the operations theory of, executive control over the Justice Department looked like when it was, tested against the constitutional framework in a proceeding where the testing was done by an institution whose independence from the political operation is structural rather than aspirational. All of that is now part of a permanent institutional record that belongs to the court and to the oversight mechanisms and to the congressional processes that are reading it, and to history, in the specific sense that history means the accumulation of documented fact that survives the political framing operations built around it. The Trump team will make adjustments. The operation is too experienced, too practiced, too deeply familiar with the specific landscape of managing politically consequential legal exposure in a hostile institutional environment to not make adjustments. The adjustments will be real. They will be sophisticated. They will be the work of serious people operating with clear eyes about a situation they understand better than the framing they're deploying suggests. And the adjustments will be made inside the landscape, the final phase created inside the documented record, inside the pattern the record contributes to, inside the reading that the institutional actors with independent standing to read it are already performing. Watch the next filing. Not for what it argues. For what the argument's relationship to the lock-in's documented findings reveals about where the operation's internal assessment of its own position has landed after the final phase. Watch the next congressional response from the actors whose procedural standing gives them independent access to the oversight mechanisms the situation has engaged. Watch for the specific quality of the signals that arrive through silence, rather than through statement, through the absences that mean something, when the absences belong to voices whose presence would cost the operation something it has decided it cannot currently afford to spend. The final phase is called final, not because it ends what comes next, but because it ends the possibility that what comes next gets to be shaped primarily by the operation's own choices, rather than by the institutional record the operation is now inside of. That record is real. The judge is locked in. The documentation is permanent. And the aftershocks of what that combination produces in courts with active matters, in oversight mechanisms with open processes, in the reading practices of institutional actors whose independent standing means their conclusions belong to the record rather than to thee, framing are still propagating through terrain whose full topology won't be visible until the processes the final phase activated complete themselves on their own timeline, by their own rules, according to their own reading of what the lock-in placed permanently in the institutional architecture of this situation. Stay close to this one, because the next signal is already building, and it will arrive the way this one arrived, not through the loudest voices, not through the most visible framing deployments, not through the press releases that tell the story the operation has chosen to tell. It will arrive through the quality of a specific silence, through the geography of a particular absence, through the asymmetry between what the documentation says and what the framing is saying about the documentation, through the unmistakable gap between a record that exists and a narrative that is trying, with every sophisticated instrument available to it, to manage the distance between where the record points and where the operation needs it to be understood as pointing. The record always surfaces. The lock-in has already happened. The final phase is not the end of the story. It is the moment the story stopped belonging to the people who were writing it.